Hi everyone, Abigail Runk here. This week I decided to look at the Scopes trial, in particular the stance of William Jennings Bryan. As the Scopes trial encompassed a very large amount of things, trying to fit this all into 5 minutes is very limited, but I digress. When we look at the Scopes trial, it particularly involved John T. Scopes, who was charged with violating a Tennessee law, which stated that anything other than creationism could not be taught in the public school classroom. As a substitute biology teacher, the textbook that he used, in a way, had evolution, but as we saw in one of our videos this week, the evolution in particular was more of a eugenics or racial Darwinism rather than the standard survival of the fittest or primate evolution Darwinism that he is primarily associated with. In Dayton, Tennessee, where the trial takes place, it pitted Clarence Darrow versus the fundamentalist William Jennings Bryan, the main person of today's discussion. Interestingly, Bryan and Darrow created a deal whereby both would essentially testify to what they knew in regards to their faith or anti-faith. Bryan testified, Darrow did not, and he pled his client guilty. The interesting aspect I find with this is that it creates a sense of double standard and irony, particularly in the fact that Bryan, who was considered part of the prosecution, was called to testify as an expert witness. My understanding of the legal system, though I am not a criminal justice major, it does seem to be that is outside of normal purview, or at least would not be acceptable in today's court system. Looking at Bryan's stance, in particular, he feared a loss of the Bible. New York Times article, July 8, 1925, in particular has Bryan stating that having this trial, if it is lost, found in favor of Scopes, would involve basically taking the Bible out of everywhere. Christianity would be completely lost. In particular, he calls it a duel to the death. Following that, in almost a sense of irony, he states that the trial will follow rules of evidence. This is stated within the Washington Post article on July 12, 1925, where it states that the laws passed must be enforced by the state using proper evidence. Yet the scientific theories that Darrow was presenting were not considered evidence at the time and were therefore rejected, and only biblical ideas could be stated, which again, putting to today's ideas, that really doesn't necessarily make sense. And according to Darrow, he followed that kind of line of thinking, stating that the courts had no right to prohibit that theory, creating, especially if you're going to argue scientific or evolution versus creationism and biblical ideas. With this sense of irony and double standards, in a way, it almost seems like this could violate biblical principles that we see at Liberty University, particularly Standards 4 and 5, which is a commitment to objectivity and honesty, which is essential to historical investigation, and Standard 5, which is the Bible provides principles of ethics that guide our evaluations of people and nations. So without bringing in the objectivity, the honesty, the different theories, and having proper discussion, even if it is in a court of law, you're not creating an objective mindset, and you're really not following an ethical standard. Interestingly, as we continue with this, Bryan had a stance which he stated in full in the Nogales International, July 13, 1925, where essentially there's a loss of religion through education, and that could be an entirely different discussion where we argued that may still be seen today in public schools and university settings that are very secularized or modern, or teaching the sense of evolution, or essentially keeping the Bible and Christianity out of any class unless it is a biblical history or theology class. So to close with this statement, Bryan is stated as saying, "The hand which writes the paychecks should rule the schools. A majority of the people of the nation believe in the Bible. The disgrace is not the law of Tennessee signed by the governor and passed by the legislature. The disgrace is that anyone would make such a law necessary. The teachers are employees of the taxpayers and should no more so allowed to teach what they personally believe than a clerk should be allowed to dictate the policies of the bank. The disgrace is that teachers should betray the trust that is imposed on them by the taxpayers. I believe the greatest menace we have today is the substitution of religion for education." I look forward to seeing everyone next week, and I'll talk to you later.